My basic argument that I presented to the court was that the Washington Constitution is a unique document. It comes from a unique historical context. In 1889, when our founding fathers in Washington adopted the Constitution, they weren't scared of the King of England. They were scared of their own legislature and the railroad barons. A big reason for that was very recently the government had given the railroad barons vast tracts of land in Oregon and Washington, and this was seen as a threat to the citizens. We'll see what happens, you never can tell. But if this ruling is allowed to stand, the Washington legislature will, and all of its aides and staff members will be allowed to act with impunity and to conceal virtually any record they desire. And these aren't words spoken in debate that someone can hear. These are words sent secretly through electronic means.
Washington Coalition for Open Government was arguing before Division 2 today that Division 2 should reverse what the trial court said or gave the legislature, which is a very broad protection from open government protections and public disclosure. Basically, the legislature now, without reversal by Division 2, any legislator in their discretion can withhold public records and then claim that it's a deliberative process and they need this information to be kept secret. We're saying no, there is a limited scope of what you may keep secret, and you haven't defined what that is. And if you're going to keep secrets, you're going to have to pass legislation that's very specific, and that's what the PRA is for.
I thought the judges asked good questions. They seem to be really interested in history and tradition. Maybe that's where this case is going to turn on, But I also haven't lost sight on basically the big picture, like what's at stake here. And it comes down to how transparent the state legislature is. And that matters not just to the litigants in the courtroom, but to everybody in Washington State.
Our way is what's expressed by the people in the 1970s through the Public Records Act. And that was, as I think Arthur West described, based on the idea that they didn't want the legislature doing their business in secrecy. The Constitution is interpreted as broadly as I was hearing that the legislature requested, to say that there isn't anything that should be subject to public records, that there isn't anything that they shouldn't be able to do in secrecy. And I can't imagine a state and a government process where that plays out.